I think we can officially kick off the webinar. Hello, everyone. Good afternoon, and welcome to another exciting edition of the ESP Practical Lawyer webinar series. My name is Jessica Ekenedu, and the moderator for today's webinar. At ESP Training Limited, we provide comprehensive continuous professional learning with courses and training across various areas of practices. We have tagged this webinar series, the launch our webinar series, and it's slated to hold at 3 p.m. during lunch break every Tuesdays and Thursday respectively. After every section, we provide resources in easy accessible format on a go for everyone who is interested, and will be streaming live on YouTube and Facebook. And today's topic is Vicarious Liability in Construction Project. The overview basically saying in construction, vicarious liability may arise when a contractor employee acts in such a way while performing their duties that can cause harm to another employee, another contractor worker, or a member of the public. The participants to this webinar will be learning all about vicarious liability in construction project. And some of the things that will be discussed is vicarious liability and independent contractor, general duty applying to the construction project. And please, if you do have any question while the webinar is going on, please you can type on the Q&A or raise your hand, and in due time it will be answered. It is a great pleasure I introduce our speakers for today. We have Mr. Bailey, who is a partner in White and Case. And we also have Mr. Ima Amadi, who is a partner at MCQ Solicitors, and we have Mr. Sheshe, who is a partner at Bloomgate. Speaker for today is Mr. Sheshe, and he will be speaking on vicarious liability and independent contractor. Over to you, sir. Hello, sir. Can you hear me?
Yes, I can. You can hear me. Good afternoon.
Good afternoon.
Okay, please give me a moment to share my slide. Okay, let me share my screen. I have a slide presentation to use. Let me just share my screen in a moment. Please give me 1 minute to do that. And while the slide is coming on, let me just greet everyone. Good afternoon to all our participants. Good afternoon to my fellow speakers in the room here. Mr. Julian Bailey, good afternoon, sir. Good to see you in the room. And good afternoon, sir, to our second speaker, Mr. Amadi. It's my pleasure to be in this room this afternoon. And I'll be speaking on the vicarious liability of a contractor as it relates to construction projects. And in construction projects, what we need to understand is that it is unique and different from all other kinds of contracts, in the sense that it focuses on building and engineering works. By their very nature, these are the kind of projects where it's inevitable to avoid injury, it's inevitable to avoid damage and loss and all kinds of hazardous situations. These things are bound to happen. So I'll be sharing my knowledge on how can approach this issue of vicarious liability. I also touch on how the contractor can mitigate the risks that are involved in these kinds of, when this kind of liability occur in a contract. So I have about 6 points to share before my time is up. So under Nigerian law, my slide is still coming on, but I'm not speaking, so I won't keep us waiting. Once the slide comes on, I will share my screen. It's still trying to load. It's taking a while to pop up. So under Nigerian law, as we all know, Nigerian law follows the English common law, and our courts have upheld in several cases that where you have an employer or a master, he is liable for the wrongful act of his servant or his employee. In the case of construction, contracts are usually structured in this manner. You have the owner of a project, who is usually called the client. So a project owner has a project, say, to build a certain kind of development, project, and he hires a contractor. But most times, this project owner does not act directly, because these are people that some of them do not have engineering background or construction background. So they have engineers who act for them, who give instructions of what they want to the contractor. The contractor is a person that has a specialized knowledge and ability to deliver and to carry out, execute this contract. And this contractor, on his own does not act alone. Talking about a multidisciplinary kind of project that involves different engineering components, from civil engineering to electrical works to all kinds of works. So it's always the case that there are different subcontractors, and even under the contractors, there are employees that carry out the instruction of this contractor to achieve the mandate that has been given by the owner of the project through the engineer. So following the principle of vicarious liability, the law is simply that any wrongful acts, any act of negligence that arises in the course of the contract, and these employees who are in the employment of the contractor, and this their wrongful act leads to an injury, leads to damage, or leads to harm of somebody else, a third party, most likely. This third party can elect to either pursue an action against the contractor, severally, or against the employee, or both of them together jointly. So it's called joint and several liability, and that has always been the position of the law, and it's a that applies in so many cases, even in cases like fundamental human rights. I've seen it applied. In construction contract, what the contractor should know that ab initio, the moment you go into a contract and you have people working for you who are carrying out your instructions, the test is that these people are under your control. Then if there's any danger, any liability, any harm, it follows that this contractor would obviously be liable for the act of the people that suffered this damage. I'm sorry, let me share my slide is giving me a bit of a challenge here. Let me just try and share the comment I have on that one here, so you can follow my discussion very, 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 very easily. Okay, I'll just keep speaking on why this slide tries to come. So the first issue I said before is that you need to identify what the liability is. The liability is that the contractor would be able to, has to indemnify or pay damages to the person that has been injured. Now, in construction contract, once the contractor is employed to deliver a project, he's independent. That is the assumption. It's independent in the sense that the owner of the project is relying on the skill of the contractor to deliver the contract. He's not going to give, he's not engaging this contractor as an employee, even though we say owner of the project is an employee, but he's engaging this contractor to deliver this project according to the way the contractor wants. But the contractor is at liberty. In fact, he's going to use his own independent, mind, discretion, ability, and skill to ensure that he delivers this project in a way that meets the demands of the employer. And even where most times where you have an engineer, an architect engineer who is supervising this independent contractor, most times the independent engineer's duty is limited to ensuring that this contractor adheres to the instructions, the design and the works that have been given to him to deliver. It's not really going to be micromanaging him or telling him how to carry out his work. So to that extent, you would say that this independent contractor is independent. The common law test is that who is under the control of the person that's committed this liability, these thoughts. So the contractor is usually enter this contract with the mindset that he is independent of the owner of the project and is delivering this project according to how he has elected to do it, as far as it meets the demands of the project. Now, there are different kinds of liability that can occur in a construction project. It is a project where, like I said earlier, it's inevitable not to have all kinds of issues that arise, and these issues can lead to liability. Commonly, it's injuries, personal injuries. You have site workers, you have foremen, you have builders, you have people handling all kinds of very dangerous materials and dangerous substances and carrying out their work in a way that is harmful. It's quite dangerous. So there's a possibility of injury, not to the site workers who are employees of the contractor, of course, not only to them really, but also to people who are not even on the site. I've had instances where on a construction site, there have been a mishap that affected surrounding around vicinity, buildings around, people who are even innocent. We've had it where I live in Lagos, Nigeria. I've had instances of things like that where there's been a problem on the site and people that are not even there tend to suffer even death. So you have death, you have personal injury, you have damage to property, which is very, very commonplace, and you also have permanent disability. These are common injuries, common liabilities that an independent contractor can be liable for in the course of delivering this contract. And the people that suffers these damages, for example, if it's a case of death, the law is that even in case of death, the estate of the deceased person has a right, can bring a claim, a claim in tort against the party that's wrong, that led to that wrongful death. So death is not a bar to liability. Rather, the estate of that person can actually bring up a claim and ask for that, for the estate to be compensated for the person that has lost his life as a result of this construction project that has been led to the injury of this person. Now I'll go to the contract itself. Now, under the contract, you have different forms of contracts. You can elect to have a bespoke contract where you draft the contract to fit the needs of the parties. I mean, where a lawyer drafts a contract just to fit the needs of the party is not following any standard form of contract. I also have the forms of contract which are standard in the construction industry and building industry, like the FIDIC, the Federation of International Consulting Engineers. That's a popular one, and they have different forms of contracts. You have the red book, you have the orange book, you have the green book, you have the silver book. But the most common one, internationally and even around, is the red book, where the owner of the project is the one that designs the works, and the engineer is, the contractor is supposed to carry out this work. Under the red book, you realize that there are condition of contracts there that imposes that speak to vicarious liability. It tells you that it's not something you can use a contract to exculpate liability from. That's how serious this point of law is. You cannot use a contract to, because the law would not give credence. The law will not honor the performance of an illegal contract. So you cannot use the contract to exculpate liability for a wrongful act of the contractor that has led to an injury of a third party. So under the FIDIC red book, I've highlighted about 4 provisions where this contract stipulates clearly that a contractor can be liable. Has some vicarious liability to bear where there's injury to parties working on that construction project. Right, so the first one is under you have the clause 4.3 of the FIDIC red book, and this speaks to the fact that a contractor can suffer liability, due to failure to adhere to health and safety regulations. This particularly is where these regulations, these health and safety regulations, leads to injury affecting the people on the site, the workmen, and even the work itself. They can have a cause to commence an action against the contractor if this injury was caused by people in his employment who have behaved in a way that their negligent act has caused damage to somebody or harm. So health and safety is very paramount. The second one I highlighted is under clause 4.8 of the FIDIC red book, and this is where, sorry, the first one is 4.3, 4.8, so the second one is 4.3, where the contractor has a right to appoint representatives. It has a right to representative and give these people full authority to act on the contractor's behalf under the contract. That means if the contractor has appointed somebody as his assigned, his agent, his representative to do something, and this person, of course, in law, we have a saying that you cannot, a person that has been delegated an authority to can't delegate same to another person. That is the saying in law. It has a maxim, it's a Latin maxim for that. Now, if the contractor there's an injury, there's a problem on the site, and this problem on the site it emanates from the rep of the contractor giving instructions, probably giving the wrong instruction or giving instructions that are not properly adhered to, and these are led to some damage, then of course the contractor cannot. This is a case of express authority now in agency relationship. It cannot exculpate itself from liability. Liability is implied, this is strict liability, and is going to bear the consequence of that liability. The next one is clause 5.1 of the Finnish Red Book. Under clause 5.1, we have the contractor here being responsible for the work of all subcontractors, for managing and coordinating all subcontractors' work, and for the acts of default of any subcontractor and even their agents. So this is also where the contractor is at liberty to appoint subcontractors. That means, of course, these are people that are under his control. This is express agency, like I said before. So he's going to be liable for their acts and their omissions, which will lead to liability on the part of third parties. Then, so yeah, talking from a commercial point of perspective now, how do we? It's not enough to talk about liability. How do we mitigate liability? How can liability be reduced or mitigated? Because that is what the contractors are going to like to hear from me this afternoon. So I've highlighted certain provision also in the Finnish Red Book, and they all touch on insurance. You know, it's very, very under Nigerian law. The law is very clear that under the Insurance Act now that when you are carrying out contracts that has to do with construction, and it's going to be above 2 floors, you have to insure that contract. And not only insure that contract, insure the contract in a way that when there are issues where there are injuries, there are problems, there are issues where people have suffered damages, and it's easy for this contractor to compensate the people that have suffered injury. Because the contractor, the person giving the project, that's the client or the employer, he's just paying money to get his job delivered. He's not looking to start paying anybody benefits, for injury or death. He's looking to take his property, his project duly delivered. So under clause 19.2.1 of the Red Book, we have insurance for works. That means ensuring the entire works that the contractor is carrying out. Most times they demand the contractor, the employer will demand to see the evidence of premium payments. I've made a payment of premium, and that will be the condition for them. Especially when you're working with very big, like government or some kind of big organizations, they want to see that you have made premium. You pay, they want to see evidence that you have insured the project and you have the proof with you before they allow you to. Pardon me, I went off for a moment. I'm so sorry about that. Can you hear me now? Am I audible in the room? My network went off for a moment. So thank you very much.
I hear you.
All right, thank you. So we have clause 19.2.2 that speaks to insurance for goods. There are goods on the construction site that are very dangerous and can lead to harm, and you don't want a situation where, for example, these goods are missing, they are lost, or they are very critical to completion of the project, and one person's negligence has led to maybe disappearance or stealing or whatever of those goods. The owner of the project would not take, I'm sorry, for an answer. He wants answers to his problem. So insurance will cover for that kind of challenge. Then you have thirdly, insurance to persons and damage. This is where you talk about personal injury, talking about personal permanent disability, talking about even death of employees, death of even, you want to know every stage around us, like around the project sites. If this place is in a place where it's a living area and any major mishap there can affect surroundings, then they should look at insurance that would mitigate that kind of occurrence. Then lastly, that's the fourth one, is 19.2.5 of the Finnish Red Book, is insurance to employees. The employees who are working on the site are the most exposed likely people to suffer damage, suffer some kind of injury. It behoves on the contractor to see how to insure these people from the injury that arise from any loss that occurs, which he will not like for that to happen. But in the eventuality that it happens, he has insurance that will cover that would make good any claim that will arise, either for life or for injury. So that's in very brief my presentation, and I'll conclude by saying that it's inevitable in construction contracts for these kind of things to arise. The law is very clear, and the courts, I mean, if you go to court, or you go to arbitration, you go to other forms of dispute resolution, they are not going to say that because of you didn't envisage this, therefore liability will not arise. Liability is definitely going to arise either jointly or severally, and it's usually on the contractor that will be held vicariously liable. So I've said earlier that insurance is one of the ways that we can mitigate this kind of risk, and also safety, adherence to safety at the workplace. And it's also not out of place for this contractor to have, if it's possible, agreement with these employees and these people working under him, extensively stipulating what he will be liable for and what he will not be liable for. So even though the third parties, they're coming after him for vicarious liability, you can also go after them for their own liability that led to his own liability. So these are practical measures I have proposed that would help a contractor to be able to manage this kind of risk. Thank you very much. I apologize for my slide not coming up. I don't know, it came up before I came online and now it just needs to come up. I'm so sorry, but I'll share the slides with the organizers of this webinar. Thank you very much.
Okay, thank you so much, Mr. Sheshe. Please, if you do have any question, please you can do type on the Q&A, and after everyone's presentation, the questions will be taken. So our next speaker is Mr. Ima Amadi. He's a partner at MCQ Solicitors. Over to you, sir.
Thank you very much, Ms. Moderator. My focus today is on the general duties that is applicable to construction projects. And I'm looking particularly in respect of English law, the Construction Design and Management Regulations 2015. But I'm aware that the general discussion is vicarious liability and how it dovetails into construction projects. Construction projects in construction, to realize a project, it's a collegiate activity in the sense that various construction professionals come together working as a team to ensure that the project is realized. And like the previous speaker said, in such circumstances, there is a likelihood that mistakes might be made, which could lead to injury or damage to either the workers there or third parties. And to that extent, there's a strict liability which will now apply to the person who has commissioned the project to be liable for such injuries or damage. However, that liability is not automatic in the sense that two key issues have to be established. First is that there has to be employer-employee relationship. So before you can get the employer liable for the action of the employee, then there has to be a relationship there. And that relationship can be expressed or implied from a contract of employment. And for there to be that relationship, there has to also be, you have to show that the worker for which you want to attribute his negligence to, impute his negligence to the employer, is under the control of the employer. And control here means being the employer determine what has to be done and how it has to be done. That aspect of the law, or the aspect of the law on vicarious liability keeps evolving. Initially, the original position was there has to be express control or employment relationship. But English law has moved a bit to also include situations where something that is similar to an employment relationship. Apart from that, the next one you have to establish is that the action of the employee for which you want to hold the employer liable is closely connected to what the employee is, or the employer has asked the employee to do. And so those, there are two limbs to this vicarious liability, and those two has to be satisfied in order to hold the employer liable for the actions of the employee or for the actions of his agent. Because of the health and safety issues involving construction, and the likelihood that because you have many people working at the site at the same time, that there might be injury or damage caused. English law has proceeded to, in statutory terms, reduce what is expected in every construction project, and to ensure that there is minimum or there's no health and safety risk involved to all the people involved in the construction project. And that's how they have come about the Construction Design and Management Regulations 2015, which was done with regulations made pursuant to the Health and Safety Act of 1974. And these regulations are intended to ensure that in any project development, the issue of risk to those involved is reduced to a barest minimum, if not eliminated. And under these regulations, what we have are people who have been identified as duty holders. And this include the client. So the client here is the person for whom the job is being carried out. Then there's a designer. Under the designer, you have the principal designer, who is the person involved in the pre-construction stage, drawing up the plans and all that on how the job has proceeded. Then you also have the designer himself. The designer there is the typical designer you have, the person who does the plan, designs the project and all that, and design what you are looking to construct. Then you have the contractor, and in respect of the contractor has, under the contractor, you have a principal contractor and you have a contractor. And usually in the principal contractor, that's usually when you have big projects where you now have a situation where you require, if you look at it, you require more than one contractor. So the principal contractor is the one who is in charge of the overall project. And the subcontractor, the other contractor is a subcontractor who deals with an aspect of the project. So, and then you now have the other duty holder is the worker. Obviously, the worker includes the plumbers, electricians, and all of that. And their duty is to ensure that the work, they have the necessary things that they need to carry out the work, and they have the skill, the necessary skill and training, knowledge to ensure that the work is properly done. So these duty holders all have their responsibilities under these regulations, and they are expected to comply with the terms of these with their duties under the regulations. For want of time, I won't go into the details of these duties, but they are all provided for in the regulations. But I can just give you an overview for the client. The client, who is the person for whom the job is being carried out for, his duty is to make sure, his duty, in a nutshell, is to make sure that relevant appointments and arrangements are made for the management of the project. Then the designer, the principal designer, his job is to plan, manage, monitor, and coordinate the pre-construction phase. The pre-construction phase is a phase before the actual construction. The construction phase is the commencement and the completion of the project. So the pre-construction phase is the period before that. Then you have the duty of the designer. The designer obviously is to ensure that appropriate design for the project is made, and reducing risk that might be caused through the design process and all that. That's the duty of the designer. The contractor, principal contractor, the main duty is to plan, manage, monitor, and coordinate the construction phase. So which is the construction phase is the commencement of the work and then the completion of the work. And then obviously the subcontractor to comply with that has been set up, the design and all that, the plan that has been set up by the main contractor. And then the worker, the duty of the worker is to ensure that he complies with what has been set out. And in doing that, making sure that the health and safety of himself and his colleagues who are working there is not at risk. So in a nutshell, the construction design and management regulations, or CDM for short, objectives are as follows. Health and safety issues are considered at the planning stage. Manage construction risk by applying the general principles of prevention. So you see the risk, you take steps to prevent it. Appointing the right people and organization to do the job. Supervising, instructing, and providing information. Cooperating, communication, and coordination, consulting, and engaging with workers. So to ensure that everything goes, because if you are able to comply with all this, health and safety at site will either be eliminated or reduced substantially. And that's why you see over here in England or in the United Kingdom, companies involved in big projects, they are happy to tell you we have done so amount of man hours without any injury. They like to flaunt that to show people what, how they have been able to comply with the health and safety requirements in that project. These regulations, they have implications if they are not complied with. If you fail to comply, the contractor can be prosecuted for failing to comply. The main body, the policeman, you can say, who ensures that this is complied with, and who, if it fails, ensures that sanctions are applied, is the health and safety executive. They can come to a site, invited or uninvited, to see what is happening there, to see that whether there's compliance with the health and safety requirements. If there are no compliance, if there's a failure, they can either carry out enforcement by way of issuing prohibition or improvement notices. The alternative they can do is to prosecute, or they can even apply civil sanctions. And then, apart from the health and safety executive, what they can do, the other implications of this is that it could lead, failure to comply with this could lead to an action in tort, in negligence. And that will now require, and this is where vicarious liability might come into play, where there's a failure and somebody is injured, or there's loss cost. The employer or the client can be sued, or even the subcontractor can be sued for the failure to comply with that. Also, it can also lead to an action for breach of contract, because the parties, the client and the contractor, are supposed to, are supposed to give a kind of undertaking to each other that they will comply with the regulations. So if there's a failure to comply with the regulations, either party can sue the other if it leads to a breach of contract. So in a nutshell, or rather in conclusion, the essence of the CDM regulations 2015 is to ensure that health, safety, and welfare of all the people involved in a construction project are paramount, to reduce as much as possible any likelihood of injury or damage. And where there's a failure to comply with these regulations, it will attract sanctions. And the sanctions can be in the form of criminal prosecution, can be in the form of notices by the HSE, which is the Health and Safety Executive, requiring the client to take steps to reduce or eliminate the likelihood of what do you call it, of risk to the workers' health and safety and welfare. And then finally, it can also, the other implication for that, for breach of it, is legal action can be taken, either in tort or in contract. I can share my paper after this. I don't have it mounted, so I can't share, but I can send it to the organizers later, and then they can share it with others. That's my seminar, my thoughts for today. If you have any questions, I'm here to answer. Thank you very much.
Okay, thank you so much, sir. Thank you for such an insightful presentation. Please, if you do have any question, you can type on the Q&A. So far, I've seen like 3 questions, and we'll take that after Mr. Bailey's presentation. Over to you, Mr. Bailey.
Thank you very much, Madam Moderator, and thank you to my co-presenters for their wonderful and thoughtful presentations. I'm going to share some slides, and I hope you can see that. Can you see my slides?
Yes, I can, Mr. Bailey. It's clear on your screen. I can see your slides.
You can. Great.
Yeah, I can. Yes, I can. Yes.
Great. Thank you. So the topic of my presentation is about vicarious liability in construction projects. As you just heard from Mr. Amadi, safety actually is highly relevant to what I'm going to be talking about. And safety is paramount on construction sites, because we know from bitter experience that construction sites can be dangerous places. So what I'm going to do is to take us through the common law in relation to vicarious liability, especially in relation to construction projects, because the issues we're talking about can cover many different industries and fields of life. But our focus today is just on the construction industry itself. So there are three things I want to cover. First of all, what is vicarious liability? It's helpful, I think, to define it. Then we can look at how vicarious liability works in an employment context. We heard a bit about that before, and I will also go into the question of attribution of liability to employers. And then in conclusion, I'll talk about how vicarious liability issues may arise in relation to property damage or injury, which is caused as a result of construction work. Okay, so where do we start? Well, let's start with a definition. And when we're talking about vicarious liability, we need to ask, what do we mean by vicarious? Well, the word vicarious means, as you can see here from the Cambridge Dictionary definition, it means experience as a result of watching, listening to, or reading about the activities of other people, rather than by doing the activities yourself. So when we're talking about things being vicarious, they're things that other people have done, not that we have done. But it's not just vicariousness that we're talking about, it's vicarious liability. And liability has a particular meaning too. And to put it in everyday terms, I've got the famous quote from President Truman about the buck stopping here. And so the question really, when it comes to vicarious liability, is where does the buck stop for someone's behavior? And if we try to draw that together, then we can perhaps offer this little definition, that vicarious liability in a legal context is where A engages in tortious or unlawful behavior, which is attributed to B. In other words, B is on the hook for A's behavior. And that arises because the law says that B is on the hook. And if there are these circumstances in which this can happen, we need to inquire as to what are those circumstances? When can someone in a construction context be held liable for the conduct of another person? And now I want to move on to the employment context in relation to construction projects. And we heard a bit about that already. Let's start with the key point in relation to employment, not only on construction sites, but generally in workplaces. And at common law, it's the duty of every employer to provide what's called a safe system of work for its employees. And there are various statements and cases that you can find. I've chosen one from a building case from the 1960s, Quinn and J.W. Green, which actually involved an employee being provided with a trestle table to stand on, and it wasn't very safe, and he fell off and injured himself. And he claimed against his employers. And I don't need to go into the facts, but the judgment of Lord Justice Salmon, he said here what the duty was of the employers. And he said the common law duty of the defendants, that's the employers, was to use reasonable care for the safety of their servant. That's an old-fashioned word for an employee, the plaintiff. So that really, I think, encapsulates the duty that every employer owes to all of its employees, which is to provide them with a safe place to work. It doesn't guarantee that nothing will go wrong, but they have to take reasonable measures to ensure that the workplace is safe. So that's the starting point. Employers owe a duty to their employees, but there are situations which are slightly more complicated, which raise vicarious liability issues, like the one I've posed here. And that is, what if you have an employee on a construction site who's put under the supervision of another employer? Well, the way we look at it, coming back to the employer's duty to its employees, that duty is said to be non-delegable. And that means that the employer cannot divest itself of its duty to its employees by putting someone else in charge, someone else to watch over the employees. That the employer takes responsibility for what happens to its employees. And what this means, therefore, is that an employer may be liable, and as we say, vicariously liable, if the other employer, who's meant to be supervising the employee, fails to provide a safe system of work. And we can see a a bit more about the legal underpinnings of this duty, which is the subject matter of today's webinar. If we go to some other case law, and this is a case from the 1950s that went to the House of Lords, which was then the highest court in the United Kingdom. This is Davey and New Merton Board Mills. And in his judgment, Lord Morton, who you see there, he set out the duty of an employer. And again, the language is slightly old-fashioned. And he said, it is well settled that if a master, that's an employer, delegates to another this duty to take reasonable care, he is liable for injury caused through the negligence of that person, because it is, in the eyes of the law, his own negligence. This is sometimes called the doctrine of vicarious liability. So there you can see, hopefully fairly clearly, the position taken by the law. The law is saying that if an employer delegates its duty to supervise an employee to someone else, then if that other person makes a mistake and causes an injury, the person's employer will be vicariously liable for that that conduct. So to put this in a construction context in relation to an actual project and an actual case, we can now go to this case, Nellams and Sandals Maintenance from 1995. This is a case that went to the English Court of Appeal, and it relates to a project in Kent. You can see the actual building there that they were working on back in the I think it was the late 1980s. And so what happened here was that you had the plaintiff, who was an employee of, I've called it D1, which is a subcontractor. They were painters. They were going in and decorating the building that was being refurbished. And what happened was here that the plaintiff what was actually made to work under the supervision of another subcontractor, which I've called D2. And what D2 said to the plaintiff was that he should climb up a high ladder and do some painting work using the particular ladder. Now, as it happened, unfortunately, that the floor was slippery, and the plaintiff pointed this out to D2 and said, hey, the floor is slippery. We need to secure the ladder or do something else. I can't go up this ladder. But sadly, D2 didn't listen to the plaintiff and said, you have to get up the ladder and do this painting. And that's what he did. Or that's what he tried to do. So he climbed the ladder, and the ladder slipped from quite a height, actually. And the plaintiff was injured. And the plaintiff sued both D1, that's his employer, and D2, that's who told him what to do, in the tort of negligence. Now, on the facts here, it was fairly clear that D2 had caused the accident by telling the plaintiff to get up the ladder and do some painting. But the plaintiff wasn't employed by D2, the plaintiff was employed by D1. So the question here was whether D1 was liable for what had happened to the plaintiff. In other words, was D1 vicariously liable for the accident and for the conduct of D2. And the English Court of Appeal said yes. Lord Justice Kennedy, who you see there, said in his judgment very, very clearly, he said it was the duty of D1, so that's the plaintiff's employer, to provide for the plaintiff suitable equipment and a safe system of work. This is, of course, is the paramount duty of every employer. He then said, in the context of this case, that meant a mobile scaffold or a properly secured or footed ladder. That wasn't provided. And then his lordship said, despite his express request, that is the plaintiff's request, they failed through their agent D2, that's the other subcontractor, to provide what was required. And so they must be held liable at common law. So there's a very clear finding there of vicarious liability against the employer of the injured worker, even though the employer didn't cause the worker to become injured. So that's a clear example, I think, of vicarious liability. Now, something I now want to move on to, which is important, I think, in the employment context, is that the world we now live in and the construction market in a number of countries has developed in a particular way, whereby you have some people who work as direct employees for construction companies, but you also have a lot of people who may, in effect, work as workers on construction sites, but they're not employees. They're provided by companies, which can be referred to as labor hire companies. And when they provide these people to work on the projects, they're not engaged as employees of the particular contractor. They're engaged on contracts, and these people are referred to as independent contractors. Now, why does any of that matter? Well, it matters in a number of ways, but when it comes to responsibility for accidents on sites and providing a safe system of work, we know that employers owe their employees a duty to provide a safe system of work. That's a paramount duty. It's a non-delegable duty. But if a person is engaged as an independent contractor, they're not an employee. So if a person is working for a contractor on a site as an independent contractor and not as an employee, then the employer is not subject to a legal duty of care to provide a safe system of work to that particular worker. And so the way the law looks at it is that it's essentially up to the independent contractor himself or herself to ensure that appropriate measures are taken. Now that needs to be qualified in a number of ways, which I don't want to go into now, but I hope you understand the fundamental distinction between these two types of workers. One is an employee, a duty is owed to them by an employer. Another is an independent contractor, and the same duty is not owed. So there are a number of factors which determine in law whether a worker is an independent contractor or not. It has been convenient in recent times for many construction companies to engage people as independent contractors and not as employees, because it can sometimes be cheaper. They don't have the same legal obligations towards independent contractors as they do towards employees. And so there are quite a number of these labor hire companies out there who provide people on a contract basis. But the law has never come up with an all-encompassing definition of when someone is an employee or an independent contractor. When it comes to independent contractors, the criteria for someone being an independent contractor or not include whether the worker in question has control over his or her work. Employees are generally told what to do, whereas in theory, at least, independent contractors control their own work. And then there's the question of equipment and who's supplying that. Employers are usually provided with their own equipment, whereas independent contractors have their own equipment. When it comes to payment, employers usually have a defined salary that they get paid, whereas an independent contractor may be paid a fixed sum for a fixed amount of work. And also in the contracts that you find between construction businesses and workers, they can sometimes refer to expressly the worker being an independent contractor and not an employee. So that is another factor too, which is relevant to whether someone is an independent contractor or not. And to understand in the context of what we've been talking about, why this can make a difference, whether someone is an independent contractor or an employee, let's go back to the Nellams and Sandals case that we were looking at a moment ago, where the poor fellow was told to go up the ladder and he fell off. Now, if the gentleman in that case was not an employee of D1, but he was an independent contractor, that would mean a big difference in the outcome of that case, because in law, because the worker was not an employee, D1 would not be vicariously liable for the accident that happened to this particular gentleman. So that's where the categorization of workers on construction sites can be quite important. All right, well, let's move on from there to look at vicarious liability for property damage or personal injury caused by a contractor. Now, what is the usual situation, at least in legal terms, when an employer engages a contractor? So an owner of land engages a contractor to build a building. In law, the contractor is referred to as an independent contractor, and the contractor is treated as essentially autonomous from the employer, and not as being in the nature of an employee. And what this means is that in the law of tort, if the contractor, being an independent contractor, commits a tort, it does something wrong, it's negligent, that conduct is not usually attributed to the employer. The contractor is seen as being independent of the employer, and therefore the employer cannot be sued in tort for the contractor's conduct. So that's the general position in relation to independent contractors who work on construction sites for the owners of the site. But this isn't an absolute rule by any means, and there are a number of exceptions to it. I won't go through all of them. I've just got four for us to look at. That is where an employer, an owner of a construction site, will be liable for the conduct of an independent contractor. Now, the first example I'm going to give is where the employer engages a contractor who is, to outward appearances, not actually qualified or suitable to do the work in question. So if the contractor appears to be quite incompetent, and yet the employer engages it, and the contractor then performs its work incompetently and causes some damage or injury, then the employer can be vicariously liable for that contractor's conduct, because the employer did not engage a competent, an apparently competent and qualified or skilled contractor. So clearly it's in the employer's interest and everyone's interest for it to do its due diligence on the contractors that it engages. The second exception I'll refer to, which is where an employer may be held vicariously liable for an independent contractor's conduct, is where the employer has directly authorized the conduct of the contractor in question. And to illustrate this, I'm going to go back more than 2 centuries to a case called Leslie and Pounds. And this was a case about a somewhat dilapidated building that was being repaired. It had a cellar which opened out onto the street. This is back in a time when there wasn't street lighting either, I should say. So a lot of the streets were dark in the world, including, of course, in the United Kingdom. And anyway, this property was not in good condition, but it was being repaired, and the cellar door that opened onto the street wasn't particularly secure. And this was pointed out by the contractors to the owner of the property. They said, look, we're fixing the property. We've opened up the cellar, but it's not safe, especially for people walking along the street. So the contractor told the owner about this door that wasn't in good shape. But the owner said, never mind, I will take care of it. So the owner gave assurance to the contractor that it would look after this problem. And the owner therefore countenanced the contractor's work being in the state that it was, which was actually unsafe. And you probably guessed what happened here. There was a person walking along this particular street at night. It was dark, and they fell down through the cellar door and hurt themselves quite badly. And they sued the owner for the injury they'd suffered. The owner said, well, I wasn't even there. The contractor was working on the property. But that defense did not succeed. And the owner was held vicariously liable for the contractor leaving the building in the state that it was, or the cellar door anyway, because the employer, the owner of the property, had actually authorized this to occur. So that's another example of where an employer can be held liable. The third example I'll give relates to what is described rather imprecisely and ambiguously as extra hazardous work. So if an employer engages a contractor to perform extra hazardous work, and the work results in a hazard to someone or some property, someone gets injured, some property is damaged, the employer may be held liable for that loss. The employer can't say, well, I engaged an independent contractor, so I'm not liable. Now, the legal question, and the courts have grappled with this without really coming to a clear outcome, is what constitutes extra hazardous work. I think we can make reasonably strong conclusions in some areas. So if for example, a contractor is working with a dangerous material, a contaminant like, say, asbestos, where if it's not handled appropriately, it can go into the environment and cause all sorts of damage and injury. A contractor that works with asbestos would be undertaking extra hazardous work. And so if something did go wrong, then the employer could be held liable for the contractor's work. So that's why I've got the picture there with the tick next to it. Now, the picture on the right with the person welding and the question mark is in relation to hot work or welding work, where it could be seen as extra hazardous, and there has been some case law that suggests as much. But welding, okay, yes, it can be dangerous when someone's working with fire. It can lead to the fire catching on and burning down property, including neighboring property. But it's an activity that can be done in a controlled way. And yes, there are risks, but they can be controlled. And so actually, I think if you look at the state of the law in relation to something like welding, it's not actually clear whether welding would be treated as extra hazardous work. So if a contractor is doing welding work and it causes a fire and the building next door burns down, it's not necessarily clear that the employer who engaged the contractor would be held vicariously liable for all of that. And my final point, my final slide of substance is to give an example of where an employer may be held liable for what is called a nuisance created by a contractor. And nuisance has a particular legal meaning, which in a construction context translates into building work which is really disruptive and goes beyond what a neighbor could reasonably be expected to go through. And the example I've got comes from a case, Matanea and National Provincial Bank from the 1930s. What was this case about? Well, it was actually about a gentleman, Mr. Matanea, who had a music school in London. This was on I think the first floor of a building. And he wanted to teach music and was singing and things like that. So the sound quality needed to be reasonably good. Anyway, the owner of the building, which was the National Provincial Bank, they found a tenant who was moving in downstairs. And at the tenant's request, that the ground floor was refurbished in a substantial way. There's a lot of construction work going on, and there's a lot of noise, there's a lot of dust, and it completely disrupted Mr. Matanier's music school. And he sued the bank for damages for the disruption to his business. He couldn't hold music classes while the work was going on. And the bank, one of its defenses was, well, we're not liable because we engaged a competent independent contractor to do all this work, and we are not liable for the conduct of an independent contractor. But here, the courts said that the conduct of the builder went well beyond what Mr. Matanier should have to endure and actually constitute a nuisance. And as a matter of law, the employer, or the owner of the building in this case, the bank, was held vicariously liable for that nuisance. So that concludes my presentation. I will stop there. Thank you.
Okay, thank you so much, Mr. Bailey. So going to the question and answer section. This question is for Mr. Sheshe, and Yamis is asking, based on the readiness of insurance companies in Nigeria to issue construction projects, especially in locations like Abuja, Nigeria, in mountainous terrains, construction done in such terrains usually involves rock blasting. What happens if insurance company refuse to issue such construction project? What can be done in such instance? Did you get my question, sir?
Yeah, I did. Thank you very much, Madam Moderator. Insurance, fortunately, is even a statutory issue in Nigeria. We have section, if I'm not mistaken, section, let me see. We have, there's a law of insurance that makes it mandatory that once the project is above 2 stories, you can actually should insure. And when something is a statutory matter, it's not, you cannot prevent a party from, it's like saying you want to prevent someone from applying the law. It's somehow, but I understand the practicality of the issue because they will not want to insure, insure something that the claim or the premium, when you come to claim your premium, claim the benefits might be so much, even more than what you have paid. But the reality is that that is one option. Like Mr. Bailey has said in his presentation, there are other options are available to the owner the contractor to secure himself from liability. So if the insurance is what is, you might even have an insurance policy and something happens that it will not even cover your policy. So it's still the same thing. So you have to, the insurance is just one aspect that gives protection, but you have to look at other aspects. So I propose things like making sure that the employees themselves know what they are doing and that their acts or their misconduct will be such that would attract liability. They will not assume that because my employer and my boss and my contractor is the one that will be liable, then I will not be liable. So they have to know that there will be consequences for their misconduct, their negligence, which the employer, the contractor would go after them while he's facing liability from the other person that's coming after him. So that way, if they know from the beginning that this is what it is, I believe that they would be more uptight and more careful in the way they go about their responsibility. But I think that's something you have to engage these insurance companies with, engage them properly on and make them see the viability of them investing their money in that kind of project. It's more of a commercial discussion, but statutorily, you have the right to insure your projects construction projects. That's my answer.
Okay, thank you so much, Mr. Sheshe. Mr. Ima, would you like to say something to that? Hello, Mr. Ima.
I'm a bit out of touch with the current position of Nigerian law, I must confess. So I don't think I can assist much on that.
Okay,
no problem,
the law is section 64 of the Insurance Act. I just saw it now, section 64 of the Insurance Act, sub 1, 2, and 3. That is where there is a provision about that. So that's the law. But I think, like I said, it's more of a commercial decision to engage these people and see if they are willing to put their money in that kind of unique terrain. Thank you very much.
The only thing I can add there is obviously for projects here in England, Julian can throw more light on that as well, is the fact that yes, projects are insured against potential damage, and in fact insured for injuries as well, potential injuries. So you have project insurance covering any eventuality that might arise in the course of construction, and in fact, and in the course of at the time construction is completed and before it's handed over.
Okay, thank you so much, sir. Our next question is from Kasali, and is saying, I understand insurance payouts are capped by the sum insured. Claims arising out of construction projects are usually huge. In the case that there is an insurance, but the coverage is inadequate to cover the liability of the contractor, how is this treated? Should I retake the question?
Yes, please take the question again.
Okay, I'll retake it. Kasuli is asking, I understand insurance payouts are capped by the sum insured. Claim arising out of construction projects are usually huge. In the case that there is an insurance, but the coverage is inadequate to cover the liability of the contractor, how is this treated?
Well, in law, when there's a liability, the principle is that where there's a right, there's a remedy. So there's a liability, and it has been established that the contractor is the party, his conduct or indirectly that of his employees has led to this liability. He has to make good the liability. He has to make good damages. So if his insurance is not enough and it's possible to make good the loss that has been suffered, he has to make good this loss in another way. That's why you have the forcing judgment, you have the monetary style, whatever things going after the property of the company or whatever it is they have, just to make good and satisfy. It's only when you've tried all these means and you're still not, you don't have enough money or you don't have enough resources to make good the judgment, then this person probably has to just make good what he has. So if you're like your insurance, your insurers have paid these claims to the party that suffered the loss, and it's not enough because they can't give you more than what you've paid as premium, then obviously you have to look for other means to make good that loss. Because if it goes to dispute resolution, of course, the contractor will likely be found liable if it is proven that it is the misconduct of his employees that led to this injury or this harm.
Maybe I can just add to that as well, and that's a very, very helpful answer and explanation. In relation to construction projects, I think as mentioned, insurance cover will be subject to limits. There'll be a deductible, and then there'll also be a cap on the amount that the insurer is going to pay. And anything that is beyond that, which represents the insured's liability to another party, has to be covered by the person who is insured. So if they are underinsured, that's essentially their problem. The one thing I can add in relation to insurance, and insurance plays a very big role in relation to a lot of construction projects. The one thing I want to add is that you sometimes get, in fact, you commonly get what are referred to as project policies. And these are policies which are taken out for the benefit of a number of contractors who are working on a project, and consultants, and also the owner of the project itself. And the idea can be, where this is done, is that if there is a claim or a cost arising from an accident or something like that on the project, someone being careless, the idea is that the policy itself, the project policy, will cover the claim and the cost of fixing whatever has been damaged. And the intention can be, it doesn't have to be, this policy will operate to the exclusion of any other liability as between the parties. So the idea being that they all pay for this insurance policy, a single joint composite policy, and that the policy is there to meet certain types of claims. So that is an example of where an insurance policy can, as it were, cover the field when it comes to paying out to people whose property is damaged or if someone's injured on a project.
Okay, thank you so much, sir. This time I would like to say something to it.
The point I would like to make is the contractor, or rather the person who is signing off who is engaging the contractor, would ordinarily be looking at would ask for insurance to see the insurance and to what extent, what amount is the person covered. And it will be risk if you assess the worth of your project. It will be risky for the client to engage somebody who is, in relation to the project, is underinsured. Because that would then mean that we will have this problem that has just been raised, where if there is any loss suffered, you will not be able to recover beyond the insurance cap. And one thing I've found with construction companies here in England, and I think Julian can help on this as well, is the fact that the speed at which they become bankrupt, they get dissolved, and another one is set up. Many of them don't have really much assets. So if you are relying on, okay, if I don't get enough from the insurance cover, I can go after their assets and recover. And you might discover that you really not see much to recover from. So the ideal thing, if I'm a client, I have to assess the potential, assuming there's a loss. I have to assess, before engaging any contractor, I have to assess what the extent of the insurance cover and the potential loss I'm going to. For instance, if I'm doing a house, let me take Nigeria for example. I'm doing a house in Ghana Island or Eco Atlantic City, very expensive real estate places. And I'm looking for a contractor, and I go to say and get a contractor whose insurance cover is about 10 million. And I have a project of 100 million, 150 million naira. And then I'm hoping that if I engage him, if there's any problem, and I will go after his assets. You will most likely discover that he doesn't have asset more up to even the insurance cover. So you will be running at a loss. So my advice to any client will be, before you engage a contractor, look at the level of insurance cover, especially when you, in relation to the job you want the contractor to do.
Okay, thank you so much, sir. Okay, we have another question. This from Amman from India, and persons asking, sir, could you please shed more light on that? Could you please share more light on the? Okay, sorry. Could you please share more light on the applicability of non-signatory (in brackets individual) in construction arbitration, whether the concept of vicarious liability will be applicable for such case, and also if the implement of such party that is non-signatory individual before arbitral tribunal is allowed or not?
Maybe I can attempt an answer to that question. So if we're looking at dispute resolution by way of arbitration, construction arbitration, we're talking about a contract between, say, an employer and a contractor, where they agree that disputes are to be decided by arbitrators, so they don't go to court. And that agreement applies as between the employer and the contractor. So for someone who isn't a party to that agreement, they can be referred to as a non-signatory. And that could be an individual like an employee of one of the parties to that particular contract and arbitration agreement. And usually people who aren't parties to arbitration agreements cannot bring actions pursuant to the arbitration agreements. And so what wouldn't normally be available, even in cases of vicarious liability, a non-signatory would not be able to rely upon an arbitration agreement to which it's not a party by definition. So I think that the thing to understand about what we've been talking about in relation to vicarious liability is essentially we're talking about liability in the law of tort, in negligence or nuisance even. And these are liabilities that arise outside of the framework of a contract. And so if we're thinking of arbitration, construction arbitration, this is a contractual mechanism for resolving disputes. Claims based on vicarious liability tend to be tort claims, and tort claims are usually dealt with in courts, in the legal systems around the world where the relevant conduct takes place. So I hope that answers your question, Aman.
Okay, thank you so much, sir. This is our last question for today. And person is asking, it refers to the example in the slide where the company's duty was to delegate to another company. Will they be both liable to the injured employee who has the greater liability, the employer who delegated his duty, or the sub-employer who directly caused or was directly responsible for the injury? Okay, I think I'll repeat the question.
It's okay. I think maybe that question was directed to me because it relates to my slides. And thank you, Clarence. That's a very good question. And what you're asking is whether, if we just come back to the case where the poor fellow climbed the ladder and fell down, and he had a claim against his employer, D1, who is vicariously liable, and also against the subcontractor D2, who was supervising him at the time and told him to climb the ladder. So he had a claim against both of them. He succeeded against both of them. And what an injured person can do when they sue someone, and what they do is claim damages. And the damages will be for the cost of medical bills, the cost of, or the lost income that they suffered, and various other related things. But that will be a particular amount of money that they get awarded as damages. And so Clarence's question is asking, well, as between D1 and D2, what proportions do they pay of this particular sum? It's not easy to give a simple answer to that question, because both under the laws that regulate the allocation of money between two defendants, the laws are very deliberately imprecise. And also all these cases depend on their facts. One of the big factors, though, is essentially what might be called blameworthiness for why the accident happened, and whether, just coming back to the case of the ladder, whether one party was far more to blame than the other. And it sounds as though that was probably the case here, where D2, despite being told by the plaintiff that the floor was slippery, D2 said, climb the ladder and get painting. And that was the real cause of the accident. So assuming that the plaintiff's employer, D1, didn't know about this, and otherwise assume that D2 was going to do the job of supervision properly, then we might say, well, actually, the real cause here is D2. So D2 should bear most of the liability to the plaintiff. But in all these cases, they're very fact dependent.
Just to add, Julian, in such a case, will it not be the case that the potential claimant will be looking at, especially if it's an issue of vicarious liability, will be looking at the person who has the ability to pay more than,
yeah, absolutely. Absolutely.
Yeah, and then look at the person and then sue. And then it may now well be the case that if the employer is sued and money recovered, the employer might have a cause of action if the subcontractor or whoever was caused it was negligent in the act, and then he can now sue to recover, to be indemnified, to recover what he has paid out as a result of the act of the subcontractor.
That's absolutely right. And look, in so many of these cases, when we're asking about or looking into vicarious liability, it's usually because we're searching for the person who has the deepest pockets, who can afford to meet the damages claim. Now, just coming back to this case about the man going up the ladder and falling down, let's assume that D2 didn't have any money, but D1 might have had some money. And in England and most other countries, it's a requirement for employers to take out insurance to cover their workers against injuries that they might suffer during the course of their work. So it could be here that an employer like D1 would be quite attractive to sue if it has the money. And the other thing I should probably mention in relation to the answer to Clarence's question about who bears the greater liability, the thing to remember here is that the claimant can choose who to sue. The claimant doesn't have to sue D1 and D2. The claimant could just sue D1, and and D1 would be liable to pay the full amount of damages to the injured worker. So if D1 has the money and the claimant sues D1, that's great for the claimant. What D1 can then do is claim what's called contribution from D2 for let's call it D2's fair share of the amount that D1 had to pay out to the claimant. But if D2 hasn't got any money, then the claim for contribution won't be particularly successful. So what this actually does, in effect, is it shifts the risk of insolvency or a party not having any great assets to the defendant, in this case, the employer. So if we're looking at doing justice from an overall perspective, certainly in relation to an injured worker, it's probably not a bad outcome.
I agree with everything that has been said by Mr. Julian and Mr. Amadi. I totally agree. What usually happens is usually do a claim for joint and several liability. So I think they've covered the field, and I align myself with the responses. Thank you.
Okay, thank you so much for such an insightful section today and a profound session. Thank you also to our speakers for speaking today on our webinar despite your busy schedule. And a very big thank you to our attendees for joining today's webinar. And want to also say thank you to our sponsors, LLP, DOA, Alliance Law Practice, and the New Practice for sponsoring today's webinar. Please, our next webinar will be on Thursday by 3 p.m. Do connect and also enjoy our amazing webinar. So thank you also to our attendees and our speakers for today's webinar. Do have a nice and enjoy the rest of your day. Bye-bye.
Thank you very much. I'll arrange to send my slides over to you.
Okay, sir, no
Thank
problem,
you very
sir.
much. That's my slides already. Thank you very much.